welcome. This is a session on what's the law on this. And as I've mentioned before via my Facebook page, everythinglocal.com, the partners have discussed, reached out, and I've agreed that we would do little snippets on what I normally do in a 1 hour class on the law. And they will then upload those snippets via their platform, which is the Everything Local Bahamas mobile app. So if you go into your app stores, you will see Everything Local Bahamas. You can download that app, subscribe for the notifications, and then anytime I or any other professional, whether it's a lawyer, a doctor, an accountant, whether it's a contractor, for instance, electrician, when any of us do a 5-minute summary on our profession, how things work, why things take so long, or what the cost is, it'll be uploaded on that platform. You'll be able to watch it and find everything local Bahamas in one place. All right, so today I am going to briefly speak on estate law, and then I'll touch a bit on property law. So estate law would be when someone in your family decides to leave by will or fails to leave a will to address the property matters they have, their assets, etc. So to put this in context for all of you, let's say you have a grandparent who owns a few acres or a few buildings, for instance, and that grandparent decides, well, they have 3 kids, they're going to leave the property to their 3 kids. They can do that by will, or they can do it by an outright conveyance to each of those persons or to them together. When it's done together, it can be done as joint tenants or tenants in common. And joint tenants would be a scenario where the 3 grandchildren, or the 3 children, so it's Mary, Sue, and Jane, would own the property equally. And should one of them pass, it then goes to the other 2 that remain. And when that's one of the 2 dies, it then goes completely to the last surviving person. That doesn't matter whether they're siblings, it's a father and mother situation, or father and child, mother and child situation. The point would be if it's joint tenants and you start with 3, every time one person passes, ownership goes to the next who remains. And then when that second one passes, the last one owns it in their entirety. Then you have the tenants in common scenario where the 3 persons each have a third, and they can do as they wish with their third. So if grandpa left 9 acres and he gave the 9 acres to them tenants in common, then the 3 of them each own 3 acres, and they can go ahead and say, well, my 3 acres, I'm going to go ahead and leave it by will for my 3 children. Each of them will get 1 acre. You can do it that way, or you can do it as a joint tenant. What I find happening, though, I see a lot of Bahamians doing wills where they're leaving the property or a house, for instance, to 5 to 10 persons. I can assure all of you that that causes a nightmare for those 5 to 10 persons when Grammy or Grandpa or Mom and Dad pass, because it's kind of hard for 2 persons to agree on how to maintain a piece of property, how to collect the rent, how to take care of the maintenance as far as the landscaping, the roof repairs, the window repairs, dealing with tenants, etc. So when you have 5 to 10, you're really asking for trouble, and I see it any given day when it's just 2 persons. So I can't advise anyone to take a piece of property and leave it to 5 to 10 persons. Okay, you're asking for trouble there. What you do with your property is on you, but as an attorney, I think as an attorney, I would advise you, from my experience, best case scenario and worst case scenario, I do not recommend leaving a parcel of land to several different persons, because when you have things like the expenses, to get the 5 of them to contribute to the expense could be an issue. When it comes down to doing anything with the property, you will then need the 5 of them. So if, for example, Grammy or Grandpa leaves them a house, and that house now goes to 5 persons, the 5 of them need to agree on turning the light on or off, and BPL will require the 5 of them to sign. And if 2 agree and 3 don't, then there's nothing BPL can do, because the owners of the property haven't spoken in one voice. They're not on the same page, they don't agree. So it can cause a problem. That's the estate law section segment for today. Land law, if you're buying a piece of property, I insist that you do an agreement of sale and have an attorney review that agreement of sale for you. I'm saying a lot of persons coming into court and law firms saying that they bought a piece of property from this person, but they didn't get a deed. They didn't get a conveyance, but they have their receipts where they've been paying for the property. And I asked the ones that I interact with, can I see the agreement of sale? I said, well, all I have is the receipt where I was paying for the property. We never signed a formal agreement. They told me when I was finished paying, then I would get the documents. I've been paying for 5 years, 10 years, for instance. So basically, you've gotten scammed. Someone pulled a fast one by you. What I would suggest is reach out to an attorney. Let the attorney know that you're buying a piece of property, or you've already been paying on it, and you would like the attorney to get involved in drawing up a formal agreement of sale, and if it is a cash purchase, a conveyance for you. Okay, it's for you and the vendor, which is the person selling, to sign off on. If it is that you see a piece of property for sale somewhere, you just can't go by whoever claims they own the property. They need to produce proof that they own the property. So I'd recommend asking for their title documents, proof of ownership, that you can give to your lawyer, or your lawyer would already request that they see the back title documents, we call it. So they have a title search company look into the property to make sure there's no outstanding mortgages, there are no court orders where this person should have signed a deed of release over to another person, there's no Order 77 mortgage action where this person lost the property in a mortgage action and already know that they don't have the original deed because the bank has it, but they've filed some affidavit of loss claiming that they've lost their original documents. There's so much things that you want to look out for, but as a layman or someone who doesn't do law, you may not appreciate and know exactly what you're looking for. You'll find yourself at the end of the day having given somebody a down payment, a deposit in thousands of dollars, or paying somebody every month for years to only find out there's nothing for them to sell to you, and then you're at court trying to sue them to collect $100 to $500 per month on the thousands you've spent, if you're that lucky. All right, so in summary, if you're doing a land transaction, speak to any attorney of your choice and find out from that attorney if they can draw up an agreement of sale for you and eventually get you to the point of having a conveyance, a recorded conveyance in your name showing proof of ownership. So again, the website is www.everything-local.com, and that's who's going to be sponsoring the legal seminars or sessions with me particularly. If you go into your app store, the app is Everything Local Bahamas. It's free on Android and iOS, and it'll send you a push notification whenever someone is doing a session if you're interested in watching it. You can submit your questions as well. So everythinglocal.com, and the mobile app is Everything Local Bahamas. It's free in your app store, so please check it out, download it, and that's where you'll get more of these. Take care. Bye.